welcome everybody. It's good to see you guys. There's still a number of folks joining, so we're just going to give it a few seconds, maybe a minute or so, just to let everybody get logged in, connect their audio and all the rest of it. And then we'll be kicking off with some introductions. So be back with you guys in just a second. Okay, that's a good amount. There are still some folks joining, but in the interest of time, we'll get going and just start with some of the introductions. So welcome. It's been a couple of weeks since our last instalment of this. Big topic today, which we were just discussing before we came on here. There's a huge audience, so there's a lot of interest in what these good folks have got to tell us today. So as you know, the topic is the long-awaited CMA report into the funerals market and the subsequent funerals market investigation order 2021. So plenty to cover. I'm sure you guys have lots of questions and a lot of interest in what's going to be discussed today. And we're very fortunate to have Charles and Terry join us, who I'll hand over to you now for probably a broader, better introduction than I can do for them. So maybe we go to Terry first and then we'll go to Charles.
Great. Good afternoon, everyone. It's good to be with you. My name is Terry Tennans. I serve as Chief Executive of the National Society of Allied and Independent Funeral Directors, often known as SAFE. We have independent private firms across the United Kingdom, over 2,000 branches in membership. It's good to be with you.
Charles.
I'm Charles Ward. I'm the solicitor, company solicitor with the ICCM. I'm also the author of Essential Law for Cemetery and Crematorium Managers, which was published in June this year, and I think it was the first book on the subject for about, well, I wouldn't say 20 years, getting on for 20 years. I've been the ICCM's company solicitor since 2005. Thank you, Julie.
Very good, thank you. And Charles, there's probably a webinar in that somewhere. If you're interested in doing a summary to these folks, we'd be, with Julie's agreement, we'd be very pleased to.
On what's on the how the
on the book, yeah.
On the book, how the book came to be written. Yes, we can do that. Yeah,
some of the key points.
We can certainly do that.
Very good, very good. Well, look, you'll know Julie, and Julie and the team will be here to take any questions afterwards. Charles, Terry, who's going first?
I think Terry.
Terry, there you go. There you go, Terry. There's your answer. Terry, I'll share my screen here, and then you can just direct me through your slides when you're ready.
Thanks, Neil. That's much appreciated.
You're welcome.
Thank you, Julie, for inviting me. Can I just say a huge thanks to all the members of the ICCM who are at the coalface and have done an outstanding job over these since March 2020. I just want to pass on our gratitude to you for the collaboration and close working you have with our members. And I also want to just give a shout out to Julie. Julie and I work on the Deceased Management Advisory Group, and it's great to partner with Julie on DMAG, which is good. So that's me done. If we can go to the next slide, please, Neil. And I just want to give you the context of regulation in the funeral sector. So just think about funeral directors and just the landscape they've faced over the last 5 years. So in Scotland, we've had the Burial and Cremation Act of 2016, and there's a draft code of practice that will become in statute the first legal code of practice. That's due presumably this autumn. And licensing of funeral directors. There are funeral inspectors, as you know, in Scotland. So there's all that. We've had 3 years of the CMA funeral investigation, which we're going to look at in a bit of detail, both looking at consumer protection as well as certainly the funeral associations brought to bear the need for quality, not just pricing. And then to cap it all, we've got the Financial Conduct Authority with prepaid funeral plans. The regulation of that will happen next July 29th. And that's good news for the consumer, but actually it will change how funeral directors relate to their clients and who controls the plans and so forth. If we can flick over then, and let's go to the Competition and Markets Authority proposed remedies. So they brought the order in on the 16th of June 2021, and they wanted a price transparency remedy. And what that means that we'll explore in a moment. But what they were also looking at was, were they going to appoint a price regulator, someone who would actually set pricing across the whole of the UK? This is a UK jurisdiction that the CMA have. They didn't go for the price capping regulator. They are monitoring the market, but we'll come to their first remedy in a moment. In terms of quality and standards, the CMA recommended to the Ministry of Justice and the devolved governments of Wales and Northern Ireland that a statutory regulator be instituted. And that was something that SAFE particularly were against, not because we're very much for quality and standards. Our great concern was that you could have a Care Quality Commission inspectorate that will be incredibly expensive, and it would favor, well, it wouldn't favor the smaller funeral directors. It will be a very expensive process, and particularly across England, where there are about 4,000 funeral directors, it could marginalize them. So we were pleased that the Ministry of Justice have said to SAFE and the NFD, let's look at co-regulation. And we are in exploration with the Ministry of Justice on what that looks like with a code, and SAFE are very much looking at finding external auditors to verify our quality assurance program for maintaining standards. And the third remedy, which will occur, is that funeral directors with 5 branches and above will have to report their revenue twice a year to the CMA, and the larger, the 10 branches and above, will have to break down exactly what is an attended funeral, an unattended, and all sorts of other costs, not the disbursement costs, but the funeral directing costs. So that's broadly what it is. So if we can go to the next slide, please. I just want to talk about, so what the CMA have ruled is what they want is a standardized price list. I've got here on this slide just the concerns about the remedy. And it's interesting, the sampling the CMA did during their investigation period was 18 independent funeral directors were interviewed. And we were pretty disappointed with that, and we've made that known to the CMA. The Scottish Government, during their 18-month investigation consultation, interviewed 55 funeral directors, and they were all-day interviews, not just for an hour or so. So here were some of our concerns that we have. You'll have this slide deck. I'm not going to go through all of them. If we can go to the next slide, please. So funeral directors have to give this standardized price list, and it will have what they call an attended service, what we used to call in SAFE a simple funeral service, and then an unattended service, what we would call as a direct cremation or burial. That has to be one click away from the homepage of the website. So if a funeral director doesn't have a website, doesn't have any social media like Facebook, Instagram, they actually don't need to put this on their website. But if they've got a Facebook, they have to put the pricing online. Now the challenge is interpreting what is one click away from the homepage. Is to hover over a navigation tab. A click or not a click is the question. And so we're in discussions with understanding that. So if you think about a navigation bar, ideally, you could have funeral prices and you hover, and then there's a drop-down menu which has the standardized price list. There's a debate within the CMA, whether that's 1 or 2 clicks. And then with mobile devices, it's even more complicated because a mobile format reshapes the design. So funeral directors, it's mandatory from the 16th of September this year that they have to have a standardized price list on their website or on a third-party comparison website, or it could be on their social media like Facebook. So that's coming in. They then have to disclose their interests. What that means is they have to disclose the ownership of the business, who are the directors, who are the partners. They also have to disclose if they have any financial interest in a comparison website, such as a funeral guide or one of the other recommended comparison websites. They also have to disclose, and this is where it's some tricky areas, disclosure of gratuities or donations. And that's for £250 above. If it's related to the funeral sector in some way or other, that has, and it's above £250 either per organisation or individual, it has to be declared on that statement, which is updated annually, I believe in March each year. So that's going to be interesting, and there's also has to be terms of business, and that will include deposits that are taken by funeral directors, and there may be a range of views. So if it's a direct funeral, they might say they want 100% of the finance up front. If it's an attended funeral, they might say we want the disbursements cost up front, and then they have to lay out the payment terms. If there are charges such as interest when they kick in and so forth. So the CMA have been very clear on that particular piece of legislation. I've mentioned about the standards and quality regime that we're in this co-regulation model. As you know, Scotland is going to be regulated. So that raises a challenge for us within SAFE. We're a UK-based organisation, and any future code, we want our members to be aligned and that there's parity. Otherwise, there's going to be quite a bit of confusion for cross-border funeral directors. So if we could go to the next slide, please. So what does this, by the way, you're not allowed to call it a CMA attended funeral on the standardized price list. You can, so this is like a sheet that goes on your website. You can alongside it put text and give an explanation. So this is what is included within the attended funeral. And there are concerns for us that is it going, is this going to confuse the consumer? And we're really keen to learn from across the sector, including your part of the sector, if there are concerns about consumer detriment, that this is not working for them. There can be a review by the CMA in a year's time, particularly if consumer detriment is felt. So what are the funeral director's charges? And breaking down the costs, the collection, transportation, and they can have other packages or prices. That's on what's called the additional options list that needs to be listed. So, for example, if the collection and transportation was outside 15 miles, then they can say, well, we charge, I don't know, 50p a mile or something like that. Where the deceased is kept needs to be declared to the clients, and then the type of coffin, and then the viewing arrangements on the attended. Is it within working hours? If a family were going to view outside, are there extra costs? So if we flip to the next slide, please, we'll talk about the unattended, which you'll all be familiar with. So no ceremony, no service, and you just need to put down the funeral director's charges, and then the cremation, and then there's a section for the burial fee. So I think that's self-explanatory. Just some, if we go to the next slide, just some other factors. This is in the standardized price list, all of this, the attended, unattended, then it's got fees you must pay. And so then the burial fee is within a 30-minute quarter speed drive. You need to list the cemeteries that will be used. So you might have a from and to price list. And then same with the cremation fee. And Charles will talk to us a bit about these aspects in a moment. If we flick, please, to the next slide. So this is also on the standardized price list. This is all on one sheet. As I mentioned, if there's an out of hours removal and any additional transfers or viewings, if there are any particular cultural requirements, in terms of the fee for the funeral officiant, that can be sort of price on application, or you could put it down. And it's understood that the bearers for an attended funeral will be a standard coffin sized weight and would be 4 bearers. And then if it was a bariatric funeral, then these are for extra bearers. Then just to think about, so I've mentioned briefly about on the website, the standardized price list goes on the website. In the office windows, it has to be displayed a minimum of, ideally A3 is what the CMA have asked, minimum A4. There are challenges where funeral directors have frosted windows and such like. Within the office, they have to have A2 size posters with the standardized price list, which is all of the things I've just talked through, attended, unattended, fees you pay, and then this additional products and services. Then they will have the terms of business, the disclosure of interest, and the ownership. And then you would have the addition, the cremation and burial fees. Those are a must. If they wanted the additional options list, that could be in a brochure, a leaflet, or it could be, I don't know many who want it in a poster. There is some disquiet about having an A2 poster, and there's certainly some concern about that, and I'm sure there'll be views here about that too. If we go to the next slide, please. So I just want to comment that actually culturally the change we're facing is significant and huge across the sector. And certainly, so are we seeing more independent funeral directors sell because it's getting complicated? Or, you know, most funeral directors are caring professionals. They want to serve clients, their families, and it's all getting tied up. SAFE's current code of practice is that you would have to give an estimate to a client. If a client phoned up, you should email and they request costs. And if there are any changes during the process, any additional services, all of those have to be communicated in our current code of practice. So it's probably the sort of change where many people will feel vulnerable. Most of you would say, well, most funeral directors know the price of their competitors. And I think some of this is a generational issue. Some of it is a cultural professional issue. Like some of my past presidents have had their prices online for 20+ years. We're pleased that there's a focus on quality and standards. SAFE has had a quality assurance scheme in place for some 15, 20 years. We're exploring our accrediting our complaints handling process. That we have an independent funeral directors college, and training is being provided, and there's lots of new interest. We're launching a new funeral directing diploma, and continual professional development is being sought. So there's a real hunger to learn and grow. The use of digital, it's really interesting looking at the sort of spectrum on the bell curve of innovation. You know, you've got the innovators, you've got the laggards. I think we're seeing a huge shift in digital. partly because of the pandemic, partly because we're just entering a new age. And I think it's a very exciting age, how digital is being used. And we know that with death registration, we've really appreciated the Coronavirus Act of 2020, which has allowed exemptions and using telephone and online. And I think we're also moving into a time of professionalization. So we're seeing much more focus rightly on customer choice. We're seeing some commercialization. We're seeing a very strong push for direct cremation. And I could make some comments about that if I was invited to. But also we're seeing the burdens of regulation. And so all of this is happening. And I'm going to stop there, Neil. And I'm sure there'll be some questions later on.
Brilliant, Terry. Thank you very much indeed. That's a great summary and well delivered. Thank you. Julie, what do you think's best? I think we'll probably go to Charles and then do some discussion and some questions afterwards. Perfect. Okay. Charles, the floor is yours.
Thank you very much. Can you hear me?
All good.
Oh, that's jolly good. Right. I don't have slides. Just from a personal point of view, I don't find they work with sort of online presentations. Other people can do better. So I would prefer just to sort of stand and deliver, which is what I'm going to do. I'm going to be talking about the legal and practical issues so far as they relate to cremation authorities. That's the owners of public as well as private crematoria, and how that fits in with the duties which Terry has already explained is imposed on funeral directors, who I suppose are the sort of prime, I'm not going to say primary target, but the primary people to whom the price transparency legislation requires. But it requires input from cremation authorities to make the whole thing possible. I'm going to split my presentation into, I suppose, 4 questions. First of all, what is the official status of the order? Secondly, why does anybody have to comply with it, which I'll be going through. What are the potential liabilities for anybody who doesn't comply with it? And fourthly, okay, I suppose from the point of view of cremation authorities, how do you comply with it? So if we look first at the status of the order, it's published by the Common Market, the CMA, the Competition and Markets Authority, following their investigation. It's their conclusion. So what is it? Well, it's not a statute. It's not even a statutory instrument. So it's not a regulation as such. But it's, at the same time, it's more than just guidance. It's more than just guidance because Section 167 of the Enterprise Act 2002 places everybody under a duty, civil duty, to comply with it. So it's slightly above guidance. It's got legal consequences, but it's not written like a statute. It's vague. I mean, what is cortege speed? I don't know. I mean, I can guess, and I'll be coming on to that later on. There's no penalties as such. So if you don't comply, you're not going to get somebody from the local council coming along to prosecute you. You're not going to get a fixed penalty. But at the same time, you can expose yourself to civil liability at the suit of anybody who suffered loss. There's no enforcement mechanism built into it. the only I mean, apart from the sort of the courts, the civil courts, the county court, the high court, the only enforcing authority is the CMA itself by taking civil proceedings for an injunction. So that is the status of the order. And the other thing is, of course, which I noticed, it's if you look at it, it doesn't read like a statute. The language is quite informal. It doesn't apply specifically to burial authorities as burial authorities. There's no obligation on burial authorities to provide pricing information on fees for burials. But of course, if they don't provide that information, how can the funeral director then provide its own information if it doesn't have those figures to hand? So you've got a lot of ambiguity in it. So from the point of view of crematorium authorities, what does it require cremation authorities to do? Well, I suppose to a certain extent it mirrors what it requires funeral directors to do, but it's more about filling in the gaps. First of all, helping by providing funeral directors with the information they need to comply with their own duties, which I think is the primary obligation on cremation authorities, and there's certainly the obligation which I think could result in civil claims if it's not done correctly. There's the price comparison duty. I often think it's like a petrol station or a pub. You display your prices. So if you're a cremation authority, if you've got a website where your prices have got to go up on your website in a structured way, they've got to be displayed at the crematorium. They've got to be provided in the same structured way to local funeral directors. And like funeral directors, you've got to make, I suppose, quarterly returns. Is it quarterly returns? You've got to make regular returns to the CMA with your figures. So that's what it requires. I would think for many cremation authorities, probably who've got a website, which I would think most have, that information is in substance there anyway, although it may need to be restructured. And so the next question for cremation authorities, okay, if it's not a statute, it's not an official regulation, why do cremation authorities have to comply with it? I think primarily there's a business case for complying with it. The figures, the breakdown, the price comparison, if you run a crematorium, they are your shop window. They have to go up on your website. And for the same reason provided to funeral directors. I suppose one advantage of having figures displayed is you can see what everybody else is doing. So that, I think, is, for me, would be the primary reason to comply if I was a cremation authority, and comply well with the regulation, because I just don't want to be left behind in the race. But as I've said, you can't be prosecuted if you don't comply, but you can be sued, because the Enterprise Act makes clear that you've got a legal duty, and it's a legal duty which you can be made accountable in the civil courts. Now, one of the people who could sue you is the CMA itself. If it's a blatant breach, the CMA can take it upon itself to apply to the courts or apply to the High Court for an injunction to force you to comply. And you've got penal sanctions attached to that. But I think if I was running a crematorium, that would not be my primary worry. My primary worry would maybe a funeral director suing me because I haven't complied with my duties to that funeral director. I haven't provided, they live next door to me, and I haven't provided them with pricing information. They didn't even know it existed. They've lost business as a result. So I think for me, that from a liability point of view, that would be my primary worry as a crematorium operator. Somebody's lost business because of my default. Because I think apart from direct cremations or some direct cremations, as a crematorium operator, you stand back. You're part of almost part of the support mechanism. The funeral director is the first point of contact. You're the next, usually through the funeral director. And of course, I suppose you could have civil claims made by the sort of serial complainer, the person who thinks, well, I've been conned, I paid too much for my funeral, and it's all because it's all your fault because you didn't display your prices properly, so I couldn't see at a glance, and you caught me at my most vulnerable when I'd just suffered a bereavement. So there's that. And of course, so you've got the raft of civil liabilities. So you've got the reputational reason to comply. You've got the prospect of civil liabilities if you don't comply. So how do you comply with it? I think there's two preliminary steps you've got to do. I think that for a crematorium operator, the first thing you've got to review your own pricing information and pricing policies. And even if you keep the same prices, you've got to restructure them so they conform to the regulations. So you've got an attended cremation or a non-attended cremation, and the various add-ons. You've got the template you've got to put your pricing information on. So my advice is you review your pricing structure. Now you rejig it so it conforms to the template. You've also got to, of course, that's the primary job. You've got to post that up on the website, you've got to publish it, but you've also got to engage with local funeral directors. And it says within 30 minutes cortege driving distance. So how do you translate? So how fast is cortege speed? 20 miles an hour? That would be my guess. Obviously be slower in some roads, but as a rule of thumb, I wouldn't think it would exceed 20 miles an hour. So if you translate that to miles, I would think you're talking about a 10-mile radius. So if I was managing a crematorium and having to comply with this order, I would be trying to make a list of all the crematoria within a 10-mile radius and notifying them formally of my pricing structure. If there's no funeral directors within 10 miles, then of course it's the nearest one after that. So that's the, I think that's the primary duty. And then of course, I've got to make my returns to the CMA periodically in accordance with the order. But of course, every time I review my prices or the services I offer, I've got to go through the whole process again. And so it seems to me that every tweak, there's a process to be followed thereafter to ensure compliance with the order. And of course, the final thing is, like with anything like this, you have to keep records. It's not good enough to comply. You've got to prove you've complied. So you've got to keep so when you notify funeral directors, you've got to make sure you've got a record of that notification. How are you going to notify? By email, by recorded delivery post, however you do it, you've got to demonstrate that you've done that. And of course, you've got to have a system of engagement with the CMA to feed back that information. So there's the administrative side. I don't think there's anything else I can say on this? So I think we can go into questions.
Okay, brilliant. Charles, thank you very much indeed for giving your take on that from your side of the sector. Julie, what do you make of it all? Where to start?
How long we got?
Yeah.
To be honest, I think the cremation sector has got away quite lightly. What we've been asked to do is not too onerous. Many crematoria already have price lists on the websites anyway, and will tell local funeral directors what the fees are. They normally get a letter when the price goes up every year. You know, so that's not a massive amount of work. I think funeral directors have got a huge task ahead of them, and I feel for Terry and these members and other funeral directors, because I think, you know, that's just such a different way of working, a sort of almost like a new mindset. Something that does worry me a little bit for crematoria is that the order says that the crematorium must put the price information on their website in a PDF format, and a lot of local authority websites won't accept PDF formats. So I don't know, it's interesting to hear that Charles say that we can't be prosecuted as such, because it may be that a local authority can't actually follow to the letter what it says in the order if they can't accept PDFs. So I guess if the information is there, then would be covered. Charles, I'd take your advice on that.
Well, I suppose it would have to be equivalent. It would have to be as good. The thing about a PDF is you can download it, you can print it off, you can do stuff with it. Whereas a lot of government websites you can't.
Yeah, I think Emma's just put a comment about her web team saying they don't like it because of accessibility.
About accessibility, because it's less
Yeah.
accessible or more?
I think it's less accessible,
Yeah.
Because it's a fixed format. You can't. It needs to be. A lot of local authority websites have talking pages now, or you know, you can do huge, great kind of screen rather than just a.
They're too clever for a PDF, aren't they?
Yeah,
a lot of websites.
Yeah. So I think that's going to be a bit of an issue, and hopefully the CMA will adopt a pragmatic approach. I think the principle is fine, having the information on the website is fine. It's just the mechanism by which we achieve that. I think we may need some understanding from the CMA.
I mean, if you don't comply to the letter, is making sure nobody suffers because you haven't complied.
Yeah.
And you can demonstrate that.
And in fact, if you're doing something over and above what you can do with a PDF, then actually you're going a step further, aren't you? So I suspect they would be that would be okay. Terry, what sort of action do you think the CMA may take against a funeral director who doesn't comply?
I'm glad you raised the PDF thing, because that has to be the case as well for us, and it's interesting hearing your response. In terms of non-compliance, what they've said to us is that they will engage with our members with private letters to begin with, and I think that they're taking a careful approach, not a strong-handed approach. But if they're, after a period of time, I think they might say you've got 14 working days to sort that price list out, it's incorrect. I think then there'll be another private letter saying, look, you haven't complied, and then there are public letters. And then they would lead down the route of court action, is what they've said. Apparently, Charles knows more about this than me, but someone said that the ultimate would be 6 months imprisonment.
Wow.
What for
non-compliance?
Well, as I say, there's no penal code attached to it.
Right.
It's a civil. You would only get it if the CMA issued an injunction against you and you didn't comply with that, then you might be you might go to prison because you haven't complied with the injunction, but that's one step onwards.
Right.
It's not. It doesn't. It's not directly as a result of non-compliance with the order.
Yeah. Yeah. Interesting.
That's quite good to know.
Yes.
I'm not quite sure how the CMA are going to resource this though, because they haven't got the staff to check every funeral director and every crematorium. I guess they'll take a sampling approach, will they?
I would think it'll be on complaint.
They have said to me, if I may, that they've got a department that will do desk research. There are some mystery shoppers, and they'll be saying to you, Julie, in ICCM, how are you ensuring your members are compliant?
Okay.
And you might say, well, isn't that your responsibility?
Our members will be compliant because they're all very law-abiding, good citizens. So I don't have any worries about our members. With our support, obviously, because I think Charles has written an article for the journal, which will be published in the autumn, which will also help. But the order itself is actually quite descriptive, isn't it? It's fairly clear as to what you have to do and by when. So if anyone hasn't read the order, I recommend that you do. As I say, for the crematoria, it's really not too onerous. And it is interesting that it doesn't cover burial fees at all. It's other than providing the information to the funeral director has to show that information.
I suppose burials are different. I mean, from cemetery operation is a different market, isn't it?
Well, it's sort of linked, isn't it?
Yeah, except it's not. I get the impression it's not as competitive.
Yeah, possibly. I suppose people tend to choose a cemetery based on location, rather than on cost. But then they choose crematoria that will have done traditionally. So, But I think Terry, your comments about direct cremation, and you said you would give your views if asked. Is this the time and the place to ask, or should we do that on a different one?
I mean, you're welcome to. I can give them. I would say, I think you've heard these from me before. Everyone has a human right to a direct cremation. I don't believe the public are really aware of what a direct funeral is and what it isn't, and that's my concern. And I think some of the marketing that goes on to the public can misguide. I think it's an educational issue, and I do have some personal views about the dignity of how we dispose of our human life. So it's from that perspective.
Thank you. Very well put. Okay, thank you. Neil, I think there's some questions have come in.
There are indeed. So we've got one from Anthony Davenport. Can someone give an opinion on what the usage returns will be? It just seems an administrative burden and not even in line with local authority reporting timeframes.
Yeah, good question. I queried, when I did my submission to the CMA, I queried why they needed this information, and certainly why they need to know what the income is and not the expenditure. I'm not quite sure I understand how they're going to work out what's happening if they've only got one element of the financial kind of whole. So, Terry, you spent a long time talking to the CMA. Have they given any indication about what they're going to use that data for?
I think that's part of the ongoing monitoring of the profitability of the market and the original concern, particularly of overpricing in the funeral director side. And we have concerns about the same exact thing about expenditure. And of course, during this global pandemic, whilst volumes are up, actually revenue is down. And then, of course, the death rate is going to fall over the next 5-10 years because of the pandemic. So they've not been very, in fact, if I could be very upfront and say, we've dealt with the Scottish Government, the Financial Conduct Authority, who are very collaborative. We have found the Competition and Markets Authority very unhelpful in giving feedback or understanding the whys and wherefores. I don't know what your experience is.
Yeah.
Yeah.
Yeah, I think yeah, some of the feedback we gave has not really been taken on board.
Yeah.
So yeah, I've never worked with them before, so I don't know if this is sort of par for the course, or if they've been particularly kind of difficult over this particular sector. But I don't know.
I think one of the things for our sector, and it may be true for yours, is that they would normally rule with big banks, big financial institutions. We are quite a unique profession, aren't we? A sector, the death care sector. And so, you know, we represent thousands of funeral director, small operators. They would not be familiar with that sort of market. And I think it's showing.
Yeah, I'm not sure they really grasped what the market is, how the market's made up. And I thought those figures you showed at the start that showed the low percentage of independent funeral directors that they actually talk to compared to the amount the market, you know, the amount that makes up the market, I think is really disappointing.
Yeah.
Thank you. Yeah.
Okay. All right. So one from Emma Parry, she says, I found the template table conflicting to the words in the order, and specifically she says, each crematorium operator must provide revenue for memorials related to crematoria services separately, and explain how they have allocated memorial revenue to the cremation services. But this is not in the table. Any idea, folks, how detailed that needs to be?
Charles, have you got a view on that?
So Bob's question again, how detailed?
For the revenue from memorials.
How detailed revenue from memorials has to be?
Yeah. I guess it's just a headline figure, isn't it?
Yeah, it must be just a headline figure, yeah.
So anything that can be considered a cremation memorial, such as your Book of Remembrance, bronze tablet, rose plaque, whatever you do.
So people know what the type of memorial it is, yeah.
Yeah, yeah. And I don't think you need to go into any more detail than what the table is asking for.
No. No, I think it just keeps to the table, isn't it, really?
Yeah.
Good.
Yeah,
all right. Sorry, thank you. All right, one from Liz Wilson-Smith. Can you confirm the timetable for local authority inputs to FDs and CMA?
Yeah. So the information required by the CMA from crematorium operators is the first working day of October 2021. So your first submission will be on the 1st of October, or first working day of October 2021. And that's the total revenue it's gained from crematoria services in the period commencing on the day the order was made, up to and including the 31st of August. So it spells it out quite clearly in the order itself. If you look at paragraph 10, it gives you that timeline. As for when I guess we have to supply the information to funeral directors by the same time frame, because I think you've got to supply that information on the same date, Terry, I think, isn't it? October 2021.
That's right. So funeral directors have to go public with the information on the 16th of September. And I think crematoria have 15 days after that in which to supply it, which takes, I think, to the 1st of October. Yeah, but many of your members are already supplied that, as you say.
Yeah.
But
I think you can do it before then.
Yes, you can.
Yes.
Yeah.
But I think by the 1st of October at the latest for giving the funeral directors that information.
Yeah.
And I suppose having that on your website in the format that it's requested, but not a PDF if your authority doesn't support PDFs.
Yes.
But again, I think it's supposed to be one click away, but that doesn't really work for local authority websites.
Well, I tell you, I mean, I read in my reading of the order, you've got the deadline for providing returns for the, as I say, the whole thing is so not specific, that, so you've got the deadline for providing returns to the CMA, but the order itself came into force 16th of June. So I read it to mean that when it comes to publishing prices and sending out information to funeral directors, it starts from day one, or as soon as you can get it out.
As I understand it, the legal order on funeral directors, there are a couple of things I haven't mentioned, is if there are advertising arrangements that are exclusive, say with bereavement services, hospitals, they have to be ended within 3 months of that 16th of June order.
Yes.
It's interesting with coroners' contracts for removals that there needs to be an open tender process. If there was any exclusive arrangement with a care home, with a hospice, a hospital, or some other venue, that has to be rescinded within 3 months, apparently. There's some grey areas that the CMA have confused us on. Yeah.
I just hope they'll be kind of gentle with us and in the first instance, as you say, sort of write and give advice rather than sort of come down heavy-handed.
Yes. We'll be coming to Charles for advice.
We'll start charging, Charles.
I think so, yeah.
Good stuff. All right, guys. I'm not sure if anybody has anything more to add, Charles, or Terry, or Julie. Looks like we're through the questions. Is there any final thoughts before we start to wrap up?
No, I have got nothing else to add. No.
Nothing from me.
I'm just Terry. Can I also ask about the CMA is making it illegal to pay or to kind of incentivize nursing homes and similar places. Is that going to be a big problem for your members?
Well, I don't think it's going to be a problem. It's because it's actually not. Again, in our code of practice, you're not allowed to solicit. So I think there's some clarity around gratuities, and so there are and donations. So I'm saying to my members, if you donate to a hospice, you have to declare it if it's over £250. It's a good thing to donate to a hospice. It's a great cause, as long as you're doing it for the right reasons. There may be some challenges around, gratuities for chapel attendants and so forth who assist, and how that is declared and so forth. So we're working on that as we speak.
Okay. I think most local authority contracts would ban the taking of gratuities anyway. So I see it as a good thing. I'm not
absolutely. We're very pleased
so.
with that. Yeah.
Thank you. I think that's all from me. Thank you very much.
Okay, awesome. Well, look, guys, thank you very much indeed for your time today. There's a lot there, and big, wide implications in many instances. So thanks for sharing your expertise and your opinions and your experience in the whole process with everybody today. It's been much appreciated and a very well attended event. So I'm sure folks have got a lot of value from that.
Okay, thank you very much.
Thank you.
Okay, guys, very best wishes. We will see you in a couple of weeks and stay well. Thank you.
Thank you.
Thanks, everyone. Thank you.
Bye-bye.
Bye-bye. Bye-bye.